All right, so maybe you have questions after you pass away. How am I going to send my stuff, my assets, my accounts to my spouse or my kids and so forth? So what I want to cover with you today is some basic estate planning, okay? Estate planning 101. So we're going to cover things like wills, living wills, trusts, how to set up your beneficiaries, durable power of attorney for business affairs and healthcare, and all types of things like that. So what I want to do is I want to try to take the high, boring and complex, and I want to make it much simpler so it's easy to understand so that you can take away a lot of information from here that will help you answer these questions, give you peace of mind, because I also know the more peace of mind that you have, you are going to enjoy the rest of your retirement much more. So let's dive in and let's cover some basics of estate planning 101. So before we dive into basic estate planning, there are some things I can do to help you, and there's some things that I cannot. So let me go through a basic disclaimer with you first so that we're all on the same page. Estate planning is generally a team approach, okay? You generally have a lawyer, a CPA, and a financial advisor. And this presentation is for educational purposes only. But I am a financial advisor. That is what I do. I'm a financial planner. We do wealth management and help people. I am not an attorney and I'm not a CPA, but we need all three together to have the right team. Look at this information today just as information that may help you and you can get with the right attorney and the right CPA. And at the end, if you need some help from a financial planner that is well-versed in this stuff, I can help you with that part. But I just wanted to be upfront with you and tell you I'm not an attorney and I'm not a CPA, and this is for educational purposes only. Don't run out and make a sudden change without seeking the right professional help. So maybe you have very basic estate planning questions, and that can seem like a very complex thing to people because they don't know where to start. They don't know what these big words mean. Again, I want to break this down to very simple, and let's start out with reviewing some basic questions. And take notes if you're a note taker. Number one, do you have a will? That's a very important question. Number two, do you have a trust? I can tell you that not everybody needs a trust. Let me say that again. Not everybody needs a trust. There are a lot of people that'll sell you a trust and all the work that goes with it. Some people may need it. Not everybody does. Number three, do you have a durable power of attorney? Very important. We're going to cover that. Number four, do you have a power of attorney for healthcare decisions? Number five, have you checked and updated your beneficiaries recently? This is a huge area. I'm going to cover it in more detail. Make sure to stick with me as we go through this. Number six, where do you keep all the documents safe? If you pass away, if I pass away, somebody has to know where these documents are and be comfortable with pulling them out so they're quickly and easily accessible. So oftentimes people will ask me, they'll say, Pete, what's included in my estate? And the first easy answer here today is basically everything that you own. So some examples of everything you own, you already know this. Your house, your stocks, your bonds, other real estate, okay? Even personal property, right? Maybe your boat, cars, other investments, etc. It's basically everything you and I own is included in our estate. Now, this is probably one of the biggest areas you're concerned about. That's maybe why you're watching this video, why you have questions. So people are often wondering, am I going to have to go through probate or can I avoid it? So let's cover this because the whole idea here is to avoid probate. And I'm sure that's one of the big reasons you're watching this. You want to know how you and your family can avoid probate. So let's look at this together. All right. If someone dies intestate, that means they have no will and their heirs will have to probate the estate. They'll have to hire an attorney or go through the courts and do all the work themselves. Most people hire an attorney and they'll have to get the assets distributed to who it's supposed to go to. So you don't want to end up in that situation where you die intestate without a will. Now, if you do have a will, Your wishes, you still get your wishes, but your heirs will still have to probate that. So that's a much simpler process, but we're even going to talk beyond that on how to avoid probate altogether. The other thing that's right for some people, but again, not all, it's going to be right for some, but not all, and that is a revocable living trust, okay? Not everybody needs this, but you get your wishes and your heirs will not have to probate your assets. So it might be right for some of you, okay? So which estate plan do you have right now? Do you have the government plan or do you have your plan? Because everybody has one of the two. So if you have the government plan, that means that you will have to go through probate. Assets can be frozen during the probate process, which just makes things complicated and frustrating. And we know that's what you and I are trying to avoid. You'll have to hire an attorney, and the court is in charge of your assets in distributing them. For property in other states, you would also have to probate in all of those other states that you own property. So your heirs would have to go through the process. We've already said that. But the big point here is it's very expensive and very stressful. It's also a long wait to distribute assets. Sometimes this takes years. Some cases don't settle for many years or almost never settle. So this can be just a long, strung out process. I want to make sure to help you avoid that. The other issue, this is all public information. So your friends and neighbor, if you were going through probate, could look up the probate information in the court database and see exactly what people own. So the other option than the government plan is there's some things you can do. One of them, not the only thing, but one of them you can do is have a revocable living trust. So if you have a revocable living trust, the trust assets are not frozen. Your heirs will avoid probate. Your trustee is in charge. Lump sum payments, or you can sprinkle, meaning some of us have different, our kids, some are really good with money, some are really bad with money, and you don't want them to get huge lump sums at one time. So you can make decisions depending upon who you're giving money to and when. Some may get lump sum, some of the money may be sprinkled to them a little bit at a time over the years. If you have a child that has special needs, they may need a different level of support and accountability. You would want to have a special needs option set up for them. If you have a revocable living trust, it's quicker to distribute assets. Things get done much quicker, much easier. And also this is private versus the government plan that we just said is public information. So that's the goal, to take things that are stressful and expensive and public information and make it private and easy and simple. So we've just asked these important estate planning questions to you, and I want to read you a statistic, and I think this is very important, and one of the probably the big reasons you're watching this training is to help you and your family. But in the next 15 years, statistically, we are going to see the greatest transfer of wealth in the history of the United States. There is approximately estimates of approximately $64 trillion of wealth that is going to get passed from one generation to the next over the next 15 years. The problem with that is many of these dollars are going to get chewed up in the cost of probate. Today, the goal is to help you set your affairs in order, to take the boring and the complex items to make it simpler for a more worry-free retirement. I believe if you get these things taken care of properly, you are going to better enjoy the rest of the years that you have left, and the same for me. So while I want you to do this, I do this as well so that you can enjoy your retirement more, have a more worry-free and peaceful retirement. People say, if I have a will, Pete, do I still have to probate? And the answer is, yes, you do. Okay, you still have to probate. So a will is fairly simple to set up. You can hire a lawyer or do it yourself online. Some of you are do-it-yourselfers. I pay someone to help me do it properly. But if you're married, you need one will for each person. So if you're married, you need two wills, okay? You need one for each of you. So if you have a will, you get your wishes, but somebody still must probate the will. It is less time and less cost to do this, but they'll still have to probate it. It goes into effect only upon your death, and the assets still go through probate, and it is still public information. And I think this is what you're trying to avoid. Here's the problem with probate. Probate may have unpredictable expenses. You might say, well, Pete, can you give me some examples? Yes, I've got them right here for you. We have attorney's fees, probate fees, appraisals on real estate or certain items, estate taxes, if that's applicable, that's for people with a lot of money, income taxes, especially on retirement plans, management fees, money owed to creditors and/or lawsuits, long-term medical care, length of time before the settlement. We talked about that. If you're going through probate, it takes a lot more time. And some estates never settle. AARP is quoted as saying that up to 10% of the estate could be eaten with probate costs. So on $500,000, that would be $50,000. On $1 million, that's $100,000. If you had $3 million, that's up to $300,000. So this is something we definitely want to correct and avoid if possible. So one of the things that can help some of you, but it's definitely not for everybody, is having a revocable living trust. If you have a revocable living trust, it is a situation like you take your assets, you put them into a basket, let's say, so there's a predetermined contract. You put these assets in this basket called the revocable living trust, and then when you pass away, it goes to your heirs. So it's set up in advance and ahead of time, and this is what happens is you're making that contract up front, who to pass that to and how to pass it on to them. So a lot of people ask me, Pete, could you just go over some of the basic terms of the trust? Just put it in a layman's terms and make this simple. And so let me do that with you. Let me just go over who and what are the different terms of a trust, okay? So first of all, you have the grantor, okay? The grantor is the name of who creates the trust. So if you were to have a trust, you would be a grantor, and if you're married, you both would. You're the ones that put the items, I said in the basket, but in the trust. I'm just saying a basket just for a figure of speech so you can picture that you put your assets into something, okay? So the grantor is the one that creates the trust. The trustee is the one that manages the trust, okay? So that would be you. While you're alive, you would be the grantor and you'd be the trustee. You would manage the trust while you're alive. Now, the successor trustee is who manages the trust upon the death of the trustee. So if you were the trustee and one of your responsible adult children was the successor trustee, that's who would step into your place after you passed away. If you're married, you'd probably have the other spouse as the trustee, and then when both of you are passed, it would maybe be one of, let's say, your adult children who's very responsible, or more than one, who would be the successor trustee or the successor trustees. Now, who receives the assets from the trust? That would be the beneficiary, okay? The beneficiary or the beneficiaries. So for most people in a family, that's going to often be the children, okay? They are going to be the beneficiaries of the trust. Now, the other documents that are important, whether or not you get a trust done, is going to be very important, the durable power of attorney. And there's two reasons for two purposes that you want the durable power of attorney. Okay, so the two reasons are, one is for health care and one is for financial, okay? So if you had problems, physical problems, that runs in all of our families, we get older, our health deteriorates. Let's say we were incapacitated in some way. We know we had memory loss, our physical abilities weren't the same. We're gonna need somebody to be able to sign healthcare documents for us and financial documents while we're alive, so everything can still run smoothly. That's why having the durable power of attorney is so important. You gotta have someone that you love and trust that can operate on your behalf if you need help with healthcare and financial decisions and taking care of those business items. Also, what you need is an advanced directive documents for the power of attorney, like a HIPAA waiver. Someone's got to be able to see your medical records and be able to help you with that. And we have to have someone that has advanced authority in order to look at your background. Then we talked about also the special needs trust. If you have a special needs child, maybe an adult child that needs some help, that he or she can't do everything on her own, we would want to make sure that you had that taken care of ahead of time. So again, life will be smoother for you during your retirement, and also after you pass, your child is going to be in good hands with good care, having the right people with accountability taking care of them for both healthcare and financial decisions. It's also important to know that when it comes to funding your trust, that means I use the example of having a basket and putting your assets into the basket. It's important to know that across the U.S., statistically, 70% of the people that have a trust never go through the final step and taking their assets and putting them into the trust, putting them into the basket, okay? So if you don't put the things in the trust and you have a trust, it will do you no good whatsoever. You have to make sure to take your assets, your items, and put them in the basket like I'm talking about. That's your trust. Now, this is a very important distinction between two types of trust: a revocable living trust and an irrevocable trust. Many people think if they have a trust that all these magical types of things happen. So let me just go through the distinctions between the revocable living trust and the irrevocable trust. If you have a revocable living trust, the main reason that you would have this is to avoid probate. You're in control of your assets while you're alive. Assets transfer from you to you as trustee while you're alive. You still control them, and you can change your mind while you're alive. It is not intended to be a tax-saving strategy. So if you have a revocable living trust, that is not the design. It is not going to, under most circumstances, it is not going to help you in any way with taxes. If you have a revocable living trust, it does not protect your assets from creditors. There is no shield of protection here. Why? Because it's revocable. You still have access to those items while you're alive. This becomes irrevocable upon your death. Once you die, you can't change it. Now, if you had an irrevocable trust, this is entirely different. That really means that you're giving things away. You're giving things into a basket and you have no more control. It's over there and it's in this separate entity. So the irrevocable trust, this is designed to protect your assets. You are legally removed from all rights to ownership of the assets, and once you do this, it's irrevocable, meaning you cannot change it. Let's say that you have a child or grandchild that needs special care. You're going to want to plan in advance for that person that you love. This might fall under the special needs trust. So let's go over what the purpose is. The purpose of this allows for a disabled person to maintain his or her eligibility for public assistance benefits despite having assets that would otherwise make the person ineligible for those benefits. So that's the first thing that having a special needs trust does. The second thing is this helps in the process. There's a trustee that's appointed to disperse assets based on certain needs. This is a person that should be there to help and have accountability with the special needs person. Why do people do this? This is for peace of mind for you, your family, and your loved one with special needs. You want to pick this person ahead of time because this is the person that's going to help your loved one after you pass. Let's just back up for a minute and go through what the purpose is. Again, review that for the durable power of attorney. This is for you to appoint someone to make financial or healthcare decisions on your behalf should you become incapacitated and cannot make decisions on your own. This is something that you and I don't love to think about, but we both know that this happens. You want to be prepared, but you especially want to be prepared in advance, okay? Examples: Alzheimer, dementia, stroke, someone on life support, all of a sudden you're incapacitated, you're not in a position to be able to make healthcare or financial decisions, we need that person assigned ahead of time so that we can have peace of mind and we don't make everybody scurry and scramble at the end once this happens, trying to get everything worked out. So the whole idea here is to have peace of mind for you, your loved ones, that your decision has been made ahead of time while you're of clear thinking and clear mind. Avoid the burden on loved ones of not being prepared with the durable power of attorney for both healthcare and financial decisions. So let me talk to you for a few minutes in this area on beneficiaries. I want to tell you in advance that this is one of the areas that almost everybody thinks they have right, but so many have it wrong, okay? Let me tell you a quick true story that happened in the early 2000s. There was a school teacher in New York, her name was Anne, and she was married and she got divorced. And then she got remarried, and she was married to this gentleman for 20 years, and she accumulated about $1 million in her retirement plan. And then, unfortunately, she passed away. Her current husband that she'd been married to for 20 years just assumed that he was going to get her retirement plan because not only did he love her, but he was married to her for 20 years. Well, they checked the beneficiary, and the beneficiary listed was her ex-husband of more than 20 years ago. This case went all the way to the Supreme Court. And you know who the money went to? It went to the ex-husband. I can just tell you from experience of doing this for 37 years, we find beneficiary mistakes all the time. I am just going to urge you and ask you to double check beneficiaries. And let me tell you a little bit about them, how they work, and how important they are. But for any account that you have set up at the bank, investments, life insurance, annuities, anything like that, if you have a beneficiary, that will be a non-probate asset. As a matter of fact, when someone dies, they don't ask to see the will. The first thing that they want to know is, who are the beneficiaries? So let's cover that together. I would write down a few notes, and then you could tell me if this is something that you might need some help with. So there's a few things I want to cover with you here, okay? I want to explain to you what POD is, TOD, and a restricted beneficiary. I want to cover that with you. Then I want to cover with you per capita versus per stirpes. So let's talk about your bank accounts, checking, savings, money market, CDs. Generally speaking, when you go into your bank and you want to check the beneficiaries, the term they use is POD, which stands for paid on death. Now, when you go in, you generally don't want to see the teller. You want to see the personal banker that's over there at a desk. That's who you want to talk to. And you want to say, could you please check my beneficiaries or paid on death on all of my accounts, okay? So that's what you do. Now, if you have an investment account that's not an IRA, a 403B, a 401k, TSP if you're federal, just a regular brokerage account with stocks, bonds, mutual funds, not a pre-tax qualified plan, the term they use there is TOD, and that means transfer on death. You'll probably see that on your statement. It might say TOD, but you want to double check that you have on everything I'm going to talk about. You want to make sure that you have a primary beneficiary, and then if the primary beneficiary was not alive, you would have a secondary, otherwise known as contingent. So you want to make sure you have primary beneficiaries, one or more people, and then second or contingent. POD is paid on death at the bank. TOD is transfer on death with an investment account that's not a retirement plan. Another option, just so you know, is that in some situations, not all, you're allowed to have a restricted beneficiary. So if you said, you know, I have this son or this daughter and they're not as good, I think we all have one person like that in our family. This person's maybe not as good with money as the others, and I don't want them to get a big lump sum right away. So you can do a restricted beneficiary. In some cases, that will give it to them over time, over a 5, 10, 20-year period. That's called a restricted beneficiary. Now, when you're setting up your beneficiaries, there are two ways to set up your beneficiaries other than just primary and contingent. There are two names you need to know and how to set up your beneficiaries correctly. The first one is per capita, and the second is per stirpes. I'm going to read this and then I'm going to go over an example with you. So per capita is by total number of individuals in a per capita inheritance. Should both parents and one beneficiary child die, the IRA would be divided equally among the remaining beneficiary children. So let me give you a simple example, okay? Let's say that this is you right here and you had 3 kids, okay? Now, God forbid, if one child predeceased you, terrible thing, but if that happened, if you died, the other 2 children would now split the account 50-50. It was set up 1/3 to go here to child A, but since child A predeceased you, the 2 remaining children would split the entire account, whatever is in the account. That's what's called per capita. Now let's cover what per stirpes is. Let's go back to the same example. This is you, okay? Let's say even if you're married, it's down to one of you remaining. Let's just go stick with the same example. 3 kids, okay? And let's just say that each child had 2 grandkids, okay? Now, most people will say, Pete, I want to make sure that if one of my children was not alive, I would want their share to go to my grandchildren. Most people do not want to disinherit grandchildren, but many times you might be disinheriting your grandchildren and you do not even know why. You don't even know it, okay? So here's the example. You have child A, B, and C. Now, God forbid, if child A died and then you passed, now if we had it set up per stirpes, let's say it was $200,000 in each going to each child. But unfortunately, child A predeceased you. But now after you passed, if we had this set up as per stirpes, this $200,000 would be split by the grandchildren, 50-50. So they would each get $100,000. So the most important thing I'm asking you to do, whether you think you already got it right or not, I can just tell you through many, many years of experience, this is an area that people, they think it's set up correctly, but for whatever reason, we catch mistakes all the time. It's either no one's on the account, it's maybe the right people, but they only have it per capita, not per stirpes. You're gonna wanna go through and check your bank account, your credit union, your IRA, 401k, life insurance, annuities. You're gonna wanna check everything. And having the right relationship with the right planner, this person should already be doing this for you because again, I'm just saying, respectfully, we see mistakes all the time. When people come to my workshops and they come in to see me, it's so common. I would say more than half the time we find mistakes. So I just urge you to take a little bit of time, get a cup of coffee, and check the beneficiaries on everything that you have, from the bank account, credit union, investments, IRAs, retirement plans, 401ks, life insurance, and annuities. Make sure the primary set up right, the contingent, and then are they per capita or are they per stirpes? So with per stirpes, remember, this is generational. So in a per stirpes inheritance, should both parents and one beneficiary child die in this example, the percentage of the IRA that would have gone to the deceased child now goes to his or her beneficiaries, which under most circumstances is probably your grandchildren. So we looked at the example of 3 kids, and if one, God forbid, predeceased you, now when you pass, their share would go to the 2 grandchildren. So let's talk about funding your trust, but I also want to remind you that many, if not most, will probably not need a revocable living trust if you do all the other things with the beneficiaries and so forth. Depends what state you're in. I'm in Florida. It's pretty simple with your primary residence through a will in most circumstances, but your state might be different. So you want to make sure to see the right legal professional to ask that question and or the right CPA. But let's talk about funding your trust. Remember I said what the big problem is? People set up this basket, the revocable living trust. They have this thing set there. And then 70% of them never take their assets and put in the basket or put in the trust. If you don't do that, it just erases the whole point of doing it whatsoever. So you want to make sure that if you get a revocable living trust, you have to fund it. The process of moving assets into your revocable living trust, let's talk about that briefly. If the asset is not in the trust, if you don't fund it, then the asset goes to probate, unless you have beneficiaries and so forth set up properly. So this would be assets under this circumstance. Let's say, for example, you have a piece of rental property and it's not in the trust. That might go through probate if you don't have it put into the trust. Now, there are assets that you might not fund into your living trust for tax reasons and or other. Let me give you some examples of that. Number one, qualified retirement accounts. Qualified plan, that's just a fancy way of saying 401ks, IRAs, 403bs. The 403b is similar to a 401k, but you work for a nonprofit, church, school, or hospital. Also, you could have, if you work for the federal government, you'd have a thrift savings plan, or the TSP for short. Or you might have an annuity that's technically an IRA, a pre-tax account. Health savings account, HSAs, uniform trust to minors accounts, uniform gift to minors accounts, and life insurance, maybe. This is where you got to make sure to talk to the right tax professional or legal professional to check to see if it makes sense. Most of the time, we don't put these things in a revocable living trust. So sometimes people will say, well, Pete, if I have a revocable living trust, do I have to file a tax return with that? Now, during the creator's lifetime, the taxpayer ID number of the trust will be the creator's, probably your Social Security number. All items of income, deductions, and credit will be reported to the creator's personal income tax return, and no separate return will be filed for the trust itself. Upon the death of the creator or the grantor, a trust will file a tax return and get its own EIN number with the IRS. So a lot of people will ask me, they'll say, well, Pete, when someone dies, how is that taxed? So let's go over how different things are taxed when we pass away. The first thing is, generally, beneficiaries do not pay income tax on money or property that they inherit. You get a step up in cost basis. This rule applies for capital gains. So let me give you an example. Let's say that you bought $200,000 of stock and you've owned it for many years, and now it's worth $500,000. When you pass away, under most circumstances, your kids will inherit that with a tax basis of $500,000. If they sold it on the date of death and it was worth $500,000, that's the value on your date of death, they would pay no long-term capital gains tax upon you passing away and them receiving that stock. Now, I'm talking about stock owned outside of an IRA or 401k. I'll get to that in a moment. If they sold it a year later and it was worth $550,000, now they would just owe long-term capital gains tax on the $50,000 because their tax basis was $500,000. So that's called the step up in basis rule. That's also true in real estate, works the same way. So we've covered a little bit about the step up in basis with real estate or stock owned outside of a retirement plan. Now let's cover an area that is a significant problem where we do say this is a ticking tax time bomb, okay? This is how IRAs, 401ks, 403bs, any pre-tax retirement plan, thrift savings plan, if you are a federal employee or were a federal employee, all this money that's in a pre-tax plan, when it does come out, it is taxable. Let's just look at an example. And I'm going to round up the numbers just to make this simple. My numbers may not be the exact percentage, but it's going to be close just to get across the point. So let's say you've done a good job and you've saved up $1 million in a retirement plan. You may have a lot more, you may have less. Let's just say this is an IRA or a 401k. If you're married, when one of you passes away, it's very simple. The other spouse can step into this and it becomes their IRA. If you're married, when you pass away, when both of you pass away, and this was going to go down to your children, they could take it as a lump sum. If they filled out the claim form on your IRA and they took it lump sum, they would owe approximately 40%, might be a little bit less than that, in federal tax. So that would be $400,000. Now, if you live in a state where there's state income tax, you'd also have to pay state. If you lived in a city where there's a city tax, then you would also have to pay that. So at a minimum, if they took it as a lump sum, they're going to immediately get that cut down to approximately $600,000. Now, it used to could be, what age do we have to start taking money out of a retirement plan? The current law is at age 73, you have to start required minimum distributions. Now, the law used to say when you pass this on to a non-spouse beneficiary, they could take out the money, the required minimum distribution, over many years. But they changed that with the CARES Act, and now this account, this IRA, must be liquidated over a 10-year period. So if you pass away, you have a good sum of money in there. Like I said, you may have a lot more, you may have less. Your beneficiaries will have to take this out and spend it down to zero over a 10-year period. We call this a ticking tax time bomb because people have accumulated most of their net worth in two places, their primary residence and their retirement plan, except this one is just heavily taxed. I just want you to be aware of it. There are some things that we can do to reduce the taxation to you for the rest of your retirement and possibly to your kids and grandkids. One of the things would be to look at the Roth IRA conversion to make some or all this money tax-free from here on out. You would just need to abide by the 5-year rule and own that for 5 years or more. But this is one of the things that we would look at. You talk about diversification with your investments. We also want to do tax diversifications. Maybe we don't convert all of it, but we look at taking some of your money and making it tax-free with the Roth IRA. So we've talked about wills, we've talked about durable power of attorney, we've talked about revocable living trust, all these different documents. So what's another problem you're going to run into and why most people do nothing is because people have a problem. We're all susceptible to this, is with procrastination, or to procrastinate, to delay or postpone action, okay? You put off doing something you know you need to do. But let me tell you why, again, you need to do this. The biggest reason why you want to get your affairs in order now is because you want to enjoy the rest of the time that you have. Whether you're single or married, you have kids, you may have grandkids. If you get this set up now, then you can put your mind to ease that this is taken care of. And people won't have to scurry last minute trying to get this stuff together when you're sick in the hospital or I'm sick in the hospital. We get this done ahead of time. You're going to enjoy retirement and life more and have peace of mind. So we're trying to simplify things for you so you can enjoy the rest of the time that you have. So really, I have just a few quick questions for you. Are you unsure what to do? You've watched different videos. Some people use lots of complex terms. It's confusing. Do you need some help making this simple for yourself? Number 2, are you avoiding the conversation just because you don't want to deal with it? I just encourage you not to procrastinate and to do it because it doesn't take a tremendous amount of time. And if we can get this right, this will give you the peace of mind that you're most likely looking for. Number 3, have you thought about the burden on loved ones when you die? Your kids, they're going to be scrambling, trying to find out what you have, who's the beneficiary, who's it supposed to go to? Will they be fighting and causing disruption within the family? This is something we want to avoid. If we can get this done ahead of time, answer these questions in a simple way, we can help you have peace of mind for the rest of your retirement years. So we've talked about a lot of things in this training, and it boils down to what is your choice for your estate. So there's 3 main choices you could look at and consider. Number 1 is to do nothing, keep procrastinating. Obviously, I don't recommend that because that's not going to help you and your family. Number 2, you could hire an attorney. As I mentioned earlier, I'm not an attorney. I don't practice law, but I would recommend that you hire a good attorney and get your documents done in advance. Most attorneys are fair priced, and I'm sure you can find one that'll help you out. And then third, your choice is you could do it yourself. You could look online for software, answer all the questions, print out the documents, and get them notarized. This would be much better than doing nothing. So you've made it this far in the video. So you may be thinking, how, Pete, can you help me? Well, let me just tell you a few ways that I help folks. So the way I do that, I can offer you a complimentary consultation. We can do a financial review of your assets and your beneficiaries. We can look at how things are set up. Are they set up the right way? Are you paying too much in fees? How are they performing? How are your beneficiaries set up? Do we have your kids set up properly if you have children, and make sure your grandchildren are not disinherited? We're going to look at the beneficiaries. the per capita versus the per stirpes. We would need to talk about that, make sure things are set up properly. Also taking in a little bit of tax planning discussion along the way. So we'll also help determine what estate planning documents you need. For example, do you really need a revocable living trust? Some people will need that and want that, but many people do not. But what most everybody does need is they need the right will documents, they need a durable power of attorney, like we said, for financial and healthcare, and an advance directive like a living will, addressing how you want to be cared for if on life support, etc. Then we're going to, again, cover these things. Revocable living trust, even though I told you I'm not an attorney, but I do the financial planning side. We'll discuss that. Last will and testament, special needs option. If you have a child or grandchild with special needs, we'll want to address that. Financial power of attorney, as mentioned, healthcare power of attorney, living will, pour over will. A lot of terms here, advance directives, double checking the beneficiary, the per capita versus per stirpes. So all of this here is to make sure we can build your plan that's going to serve you and your loved ones and your entire family the best. That way you don't have to depend on the government plan that may not have your best interest in mind. So if you want my help building your plan so you can avoid probate, make sure to schedule your complimentary meeting down below. We look forward to helping you protect your family and avoid probate.